Welcome back to the Deep Dive. Today, we are wading into some seriously murky waters.
We certainly are.
We're talking about that razor-thin gap between a bad thought and a bad deed.
hmm
We all understand that simply thinking about committing a crime isn't illegal.
That's right. In a free society, we do not have the thought police. You're free to think whatever wicked thoughts you like.
Exactly.
Yeah.
You can sit on your couch, plot the perfect bank heist down to the second, and as long as you stay on that couch, the law can't touch you.
Mm-hmm.
But on the other hand, society doesn't want to wait until the bank manager actually has a gun in their face.
Or worse, until a victim is bleeding out on the floor.
Right, before the police can intervene. So you've got this tension. Step in too early, you're punishing fantasies. Step in too late.
Innocent people get hurt. It is a massive balancing act. We're trying to pinpoint the exact moment a person crosses that line from just a dreamer to an actual criminal.
So that is our mission for this deep dive. We are analyzing the law of attempt. We're going to look at how the legal system punishes those who try but fail. And looking at your notes, this seems to be a journey from, well, total chaos to a much more structured, modern test. What's our roadmap here?
We have a lot to unpack, so we're going to break this down into 4 distinct phases. First, we need to understand the origins and rationale, basically, why do we punish failure at all?
Okay.
Second, we'll look at the mental state, the mens rea. And this is tricky because, as we'll see, you actually need a stronger intent to be guilty of an attempt than you do for the completed crime.
That sounds completely counterintuitive. I'm ready for it. What's
Yeah.
after the mental state?
Then we move to the physical side, the act, or actus reus. This is where legal history gets really messy with these old proximity and equivocality tests.
Right.
And finally, we'll see how the Model Penal Code, or the MPC, basically swooped in to fix all that confusion with the substantial step test.
Okay, let's dive in. I was actually surprised to read that attempt wasn't always a crime. If I tried to stab someone in medieval England but missed, I just walked away free.
For the most part, yeah. Early English law was very results-oriented. If there was no harm done, no blood, no stolen goods, there was generally no crime. The concept really started to develop in the Court of Star Chamber.
Star Chamber. That sounds ominous.
It was. It was a special court designed to correct defects in the common law. They operated on a doctrine called voluntas reputabitur pro facto.
It means.
The intention is taken for the deed.
So they swung the pendulum to the opposite extreme. Intent is everything. Results don't matter.
Exactly. But the modern doctrine, the foundation of what we use today, really crystallized in 1784 with a case called Rex v. Schofield.
Right. I have the brief here. This is the big one. So let's analyze Rex v. Schofield. First, lay it out for us. What are the legally dispositive facts?
The facts are simple, but evocative. The defendant, Schofield, he rented a house. He placed a lighted candle and some combustible material, wood chips, tinder inside the house with the intent to burn it all down.
Yeah.
However, and this is the key, the house did not actually burn. The plan failed.
So, no fire, no damage. What was the core legal issue facing the court?
The issue was whether an attempt to commit a misdemeanor was itself a crime. See, back then, arson was just a misdemeanor, not a felony. So Schofield's lawyers argued, hey, the house is fine, no harm, no crime.
Classic defense. So what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court rejected that argument and established a rule that is still cited today. The intent may make an act innocent in itself criminal, and that rule effectively has 2 elements. First, an intent to commit a crime,
Okay.
and second, an act done in furtherance of that intent.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, intent?
Well, the court looked at the purpose behind Schofield's actions. I mean, lighting a candle is, generally speaking, a perfectly innocent, lawful thing to do.
Sure.
However, the court found that the intent to use that candle to set a fire transformed the nature of the act. They reasoned that the completion of the criminal act isn't necessary to constitute criminality if that wicked intent is present.
Understood.
Yeah.
Now what about the second element, the act?
The court found that placing the combustible materials and the lighted candle, that constituted a sufficient overt act. It wasn't just a bad thought or fantasy anymore. It was a physical manifestation of his intent. He'd taken real steps.
And after analyzing all the elements, what was the court's final conclusion?
The court affirmed the conviction. And this holding was momentous because it shifted the focus from the harm caused to the dangerousness of the actor. This was later solidified in Rex v. Higgins in 1801, which established that attempts to commit any felony or misdemeanors are indictable offenses.
Okay, so Schofield establishes that attempt is a crime. We don't wait for the fire. But now we have to get inside the head of the accused. You mentioned earlier the mental state for attempt is tricky. So can I be convicted of attempt if I'm just acting recklessly?
Generally, no. And this is a huge trap that law students and even some lawyers fall into. The general rule is that attempt requires specific intent. You must intend the specific result of the crime.
So being reckless or negligent isn't enough.
No, you cannot attempt a crime defined by recklessness, like, say, involuntary manslaughter. I mean, just think about the words. You cannot intend to be unintentional. You can't try to make a mistake. To attempt something, you have to be actively trying to achieve it.
Can you give us an example to make this concrete? Because I feel like that line could blur in real life.
Certainly. Let's look at a shooting scenario with 4 people, A, B, C, and D. They all shoot at their enemies. Person A shoots and kills. That's murder. Person B shoots and misses. That is attempted murder. Person C's gun misfires. That's also attempted murder. Person D gets stopped by the police just before firing. Also attempted murder.
Okay, that seems straightforward enough. They all wanted to kill.
Right. But here's the contrast. For a completed murder, the law actually accepts a lower mental state. If you act with depraved heart, recklessness, say, you shoot a gun into a crowded train car, not targeting anyone, just not caring if you hit someone and someone dies, that is murder.
Right, because you showed extreme indifference to human life.
Exactly. You didn't intend to kill that specific person, but your recklessness was so extreme the law treats it as murder.
I'm with you.
But if you shoot into that same train car and you miss, you are likely not guilty of attempted murder.
Wait, really? Why not? You're just as dangerous.
Because attempted murder requires the specific intent to kill. Depraved heart or recklessness isn't enough for the attempt charge. Since you didn't specifically aim to kill anyone, you can't be said to have attempted to kill them. You'd get charged with reckless endangerment or assault, sure, but not attempted murder.
That is a crucial distinction. It feels like a bit of a loophole, but logically, I guess it makes sense. You can't attempt the unintended.
Precisely.
But let's push this intent rule. What if someone knows bad things will happen, but doesn't necessarily desire them? I'm thinking of that demolitionist hypothetical from the text.
Oh, yes. A classic. So picture this. You have a defendant who wants to demolish a building, maybe for an insurance scam. He knows there are people inside. He knows that if he blows it up, it is virtually inevitable, practically certain that they will die.
But he doesn't want them to die.
Strictly speaking, no. He just wants the building gone. If they miraculously survived, he wouldn't care. His goal is the building.
Okay, so he pushes the plunger, but the bomb fails. It's a dud.
Yeah.
Is it attempted murder?
Based on what we just said, if his specific intent was just to destroy bricks,
Then maybe not.
under a really strict common law reading, you could argue no. His specific intent was property damage, not killing. However, the Model Penal Code, the MPC, steps in here. The MPC says, yes, this is attempted murder.
Okay, good.
The logic is that manifesting such extreme dangerousness by acting with knowledge of virtual certainty is functionally the same as intent. If you know they will die and you do it anyway, the law says you intended it.
I'm glad the MPC closes that loophole. It would be wild to let that guy off. Okay, so that's the mind. Let's pivot to the body, the physical side. We know you need an act,
Yeah.
but how close do you have to get?
This is where the law struggled for centuries. It's a battle between two big theories, proximity and equivocality.
Okay.
The proximity approach asks simply, how near were you to success? Early on, there was a suggestion in a case called Regina v. Eagleton that you needed the last proximate act, like actually pulling the trigger.
That seems way too dangerous. You have to wait until the bullet is in the chamber.
Exactly, which is why it was rejected pretty quickly. Think of a slow poisoner. If you need the last act, you can't arrest them until they administer the final fatal dose. But clearly, the first dose is an attempt.
Right.
So the courts moved to Justice Holmes's view. Dangerous proximity. It's more of a sliding scale weighing the gravity of the crime against the probability of success.
But then there's this other test, the equivocality approach. I love the Latin phrase for this. Res ipsa loquitur.
The thing speaks for itself.
Right. What does that mean here?
This test says the act is only an attempt if the act itself proclaims the defendant's intent. You shouldn't need a confession to know what they were doing. The idea is, if you watched a silent movie of the act, would you know a crime was happening?
And we have a perfect case for this. It involves a car in New Zealand. Let's analyze Campbell and Bradley v. Ward. This one really frustrated me. First, what are the legally dispositive facts?
So Campbell and Bradley were in a car with a third man. This third man gets out, enters a parked car on the street, But then the owner of that parked car suddenly appears.
Bad timing.
Very. The man hops out, runs back to his friends, and they drive off. Nothing was taken. But later, after being caught, they confessed to the police that they had planned to steal a battery and a radio.
Okay, so we know they were thieves because they literally admitted it. What was the core legal issue?
The issue was whether the act of simply entering the car constituted a criminal attempt, specifically under that equivocality test.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
They applied the equivocality test, and this rule has two main elements. First, there has to be an act towards the crime. Second, and this is the important part, the act itself must unequivocally demonstrate criminal intent without relying on any confession or other external evidence.
So if the act could have an innocent explanation, it's not an attempt.
That's the rule.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the act?
The court looked at the physical conduct, the man opening the door and sitting in the driver's seat of a stationary car. That was the undisputed act.
Understood. Now, what about the second element? Unequivocal intent. This is where it falls apart, right?
Right. The prosecution failed here. The court reasoned that entering a car is equivocal. It's ambiguous. A person might enter a strange car because they're drunk and want to sleep it off, or they might have just mistaken it for their own car.
But we know that's not what happened here.
It doesn't matter under this rule. The court said if you strip away the confession, the act of sitting in a car does not speak for itself as a theft. It's like stopping a movie halfway through. If you can't tell how it's going to end, it's not an attempt.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was overturned.
That feels incredibly strict. They confessed.
We
know they weren't drunk or confused.
It is very strict, and it protects civil liberties. It prevents police from assuming the worst about ambiguous behavior, but it also lets clear criminals go free just because they weren't obvious enough about it.
Let's look at another example of how tricky the act can be. You mentioned something called the bunco scheme.
Yes. This illustrates the indispensable element test, which is really just another version of the proximity rule.
Okay, what's the scenario?
A con artist has a roll of fake money. He meets a victim and convinces them to withdraw a bunch of cash from their bank to prove the bank is safe. The secret plan, of course, is to switch the real cash for his fake roll.
Classic con, but where's the failure?
The failure happens if the victim goes to the bank, stands in line, but then gets a bad feeling and decides not to withdraw the money. So the question is the con artist guilty of attempted theft at that moment?
He has the fake money. He did the whole pitch. I have to say yes.
Under the indispensable element test, arguably no. The reasoning is that the thief never got control over the indispensable element, which is the victim's cash. Until the cash is on the table, the proximity is just too distant.
These loopholes are maddening. It feels like we are letting dangerous people off on technicalities just because their victims got lucky. Is there a modern rule that fixes this?
Yes, and this brings us to the modern standard used in most U.S. jurisdictions today. The Model Penal Code, or MPC, Section 5.01. The drafters of the MPC saw that proximity was too arbitrary and equivocality was way too lenient.
So how does the MPC fix it? What is the rule?
The general rule under the MPC is the substantial step test. A person is guilty of attempt if they commit an act or omission that is a substantial step in a course of conduct planned to end in the crime.
Okay.
But there's a crucial modifier. The step must be strongly corroborative of the actor's criminal purpose.
Strongly corroborative. That sounds like it bridges the gap. It uses the act to back up the intent. Let's see this in action with the Still and Mash case. This seems to be the illustrative holding for the MPC. So let's analyze the Still and Mash holding. First, what are the legally dispositive facts?
Okay, so the defendant was found in possession of a still equipment for distilling alcohol and mash, which is the fermenting ingredient. But he hadn't lit the fire or started the actual manufacturing process yet.
And what was the core legal issue?
The issue was whether mere possession of these materials constituted an attempt to manufacture illicit beverages, even though the process hadn't begun. Under the old proximity test, he might have walked free. He wasn't close enough.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
They applied the MPC substantial step rule. So, element 1. The actor must take a substantial step toward the crime. Element 2. That step must be strongly corroborative of the criminal purpose. And element 3, specifically, the MPC says that possession of materials serving no lawful purpose can be such a step.
Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply the first element, substantial step?
The court shifted the focus. Unlike the proximity test, which asks how much is left to do, the MPC asks, what has the actor already done? By assembling the equipment and ingredients, the defendant had done a substantial amount of the work. That's the step.
Understood. Now what about the second element, strongly corroborative?
This is key. A still and mash have no reasonable lawful purpose for a regular citizen. You don't use them to bake bread. Therefore, the possession itself strongly corroborates the intent to manufacture alcohol. It proved the firmness of purpose.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was upheld. And this case really represents the shift from punishing a dangerous proximity to punishing a dangerous person. The law intervened early because the person had already shown how dangerous they were.
And the MPC actually lists things that automatically count as substantial steps, right? Just to make it clear.
Correct. The MPC explicitly lists acts that are sufficient, provided they corroborate the intent. These include 1, lying in wait or searching for a victim. 2, enticing the victim to the scene. 3, reconnoitering, casing the joint.
Right.
4, unlawful entry, which, by the way, would have convicted the guys in the Campbell car case.
Ah, there it is.
And 5, soliciting an innocent agent to do the dirty work.
That checklist is incredibly helpful. It feels like the MPC really did its job closing those old loopholes. So we've covered history, intent, acts, and the modern solution. For the listener who wants to organize this or maybe ace an exam, can you synthesize it into a framework?
Absolutely. If you are analyzing an attempt scenario, use this diagnostic checklist. First, check the charge. You must attach attempt to a specific crime. It has to be attempted battery or attempted burglary.
Yeah.
Second, analyze intent, mens rea. Ask yourself, does the defendant have the specific intent to commit the target crime? And remember, the trap, recklessness or negligence is not enough. No such thing as attempted involuntary manslaughter.
Got it.
Third, analyze the act, actus reus. If you're in a common law jurisdiction, apply proximity, are they dangerously close, or equivocality, does the act speak for itself? But if you're in a modern MPC jurisdiction, apply the substantial step test. Has the actor taken a substantial step that is strongly corroborative of their criminal purpose? Look for those markers: lying in wait, possession of tools, casing the scene.
And the conclusion.
Finally, conclusion. If intent plus act are met, the defendant is liable. It doesn't matter if they failed because of bad aim, police interception, or a jammed gun. They are guilty.
That is a powerful summary. Thank you for unpacking the legal architecture of failure. It really highlights that in the eyes of the law, trying and failing is often just as dangerous as succeeding.
It is, and I'll leave you with one provocative thought to chew on. We've established that the attempter has the exact same malicious intent as the successful criminal, the same moral guilt. The only difference is luck.
A sneezing victim, a jammed gun.
A siren in the distance. So if we punish the intent and the dangerousness, why do we almost always give lighter sentences for attempts than for completed crimes? If the heart is just as black, why is the prison term shorter?
That is definitely food for thought. Until next time.